I don't know.
Got one.
You
Okay.
Released from jail at 10 a.m. on Monday, February 1st.
All right, I got one that says that too.
That is for the trespassing on misdemeanor offenses.
So ready to go. They don't, I did talk to him, but he didn't. And I haven't talked to Franklin at all. I think it's reasonable, so I'll get with her. And I haven't talked to the we'll see. Yeah. I talked to you.
Okay, you want to go ahead and go on the record? Okay, got the microphones?
On the record.
Okay, good morning, everyone. Welcome to Drug Court. I'm Judge Martin. All right, Ms. Farrell for the state attorney will call the docket, please.
Yeah, we could start with Christopher Belcher.
Okay.
He's on page 1, 16 CF 2036, 16 CF 2241, and top of page 2, 17 CF 1487.
Okay, Mr. Belcher, good morning. All right, Mr. Darrow, you're representing Mr. Belcher. Do you want to update the court on the status with him?
Judge, no major changes. He is in project recovery. How much longer did you say you had to go, Chris? Another month or so, month and a half?
Yeah, around here.
Can we set him maybe 3 weeks out just for status?
Let me look at what's, I think that might be our training date. I think that's our date that we've got a training.
18, yes.
So I could go 2 weeks or 4 weeks, and of course we
4
can.
weeks. And if something happens before then, I'll let you know.
Okay. All right, then we'll do February 25th on all 3 cases, please, Madam Clerk. Mr. Belcher, I'll set you out a month, but we can always address things sooner if need be. The team did have some further discussion on your request for a release, and the majority of the team, minus your lawyer, was not in favor of that. So I'm going to defer and have you continue with Project Recovery as discussed. I am mindful what that means to you. I understand that, but we're going to stay the course as far as what options I'm able to afford you right now. But I did want to let you know that we promised to talk about it. Mr. Darrow did raise it. We talked about it, but we were unable to get any agreement on that. And frankly, I share the concerns with the team of having you out at this point. I think we need to have you stay the course. So I'll see you on the 25th. And if you need anything, you can reach out to your attorney and we can discuss it sooner. Okay, sir?
He's still talking about like a dismissal on completion.
That is what was discussed, yes. So that's a pretty good pathway for you. I just need you to try to keep your focus and get it done.
All right, no problem.
Okay, Mr. Belcher, good luck.
Next would be Michael CF 321, bottom of page 2, 19 CF 7, 19 CF 744, top of page 3.
Okay, and I did admit Mr. Fayette. Good morning, Mr. Fayette.
Morning, Judge.
Are you hearing me okay, Mr. Fayette? I don't think you're
I can,
on mute.
Judge. I think I'm on. Can you hear me?
I see you talking. You don't look like you're on mute, but I have no sound, so you might not have a microphone
How
turned
about now,
on
Judge?
somewhere.
Nothing now? I'll go out and come back in.
Quite read your lips. Probably don't want to. He's dropped off and he's gonna come back on. Mr. Burke, I'm just getting your attorney connected here. Good morning, sir. Good. How are you doing?
Good, thank you.
Oh, all right. Everybody else is telling me they can hear him. That means
How's that, Judge?
much better. The error was on my end. Whoever was here before me turned off the speakers of the computer. So you were the first person to test drive those.
Okay.
My bad. Thank you to the team for texting me immediately. We can all hear him. He's fine. Okay, so Mr. Fayette is present by Zoom and Mr. Burke is present by Polycom. Mr. Fayette, do you want to update the court as to the status of things on Mr. Burke?
Judge, so our plan today is to enter a plea. He has completed Project Recovery. He was supposed to this morning at 7 a.m. get the to get his certificate. So if we can acquire him or have him hold that up or have somebody at the jail take a look at it that shows that he's completed it.
Okay, he is holding up what looks very much like a Project Recovery certificate. So I'm comfortable with that. If the state is, do you want to have the jail take a look at it and tell us what it is?
No, I trust that it's considered it. However, I have no restitution.
Right, I'm not sure if Mr. Fayette had addressed that yet. The next issue, I think, was restitution. Do you have an update on that, Mr. Fayette?
I do, Judge. I have the restitution. I collected the restitution yesterday. It is in my trust account. I had sent an email over to Ms. Farrell to just get me an address of where I send the check. But as an officer of the court I can represent, I have that money. It's cleared and it is in my trust account. I think it's $165.
Okay, I was going to ask the amount next. Does $165 sound right, Ms. Farrell? She's double checking. 169.
That's what I collected. I'm sorry. Whatever number she emailed me yesterday, that's what I collected.
Okay.
It would be on his restitution order.
Okay. Yeah, 169 is also what I have, and then there was another one of 250. My notes are 169 at 20 a month and 250 at 25 a month. Perhaps that was already paid. I don't know.
I didn't see that yesterday in the email from Ms. Farrell. If we missed that, I can call the family and collect that. They've been pretty Johnny on the spot.
Okay, that's just informal notes that I kept at the time of sentencing, so I just wanted to double check. My notes are sometimes not accurate.
Yeah, I don't really remember. The only criminal district was the capital of the local jail.
Right.
The other charges dropped, so I think that's.
Okay, let me just double check something very quickly, and then I can. I hate the new judgments. I can't find anything on them. Let's see.
Did Mr. Darrow's office get really big or is he in the hallway?
Mr. Darrow's in the courtroom on Zoom.
Oh, I see.
2 Alpha.
I got it.
Okay, this case, 20 CF 321 is the 169 to Global Tel. Let me just check the other one real quickly. Make sure.
Oh, I see what it was. It was carried over from the previous case, which actually was a violation of probation on a drug charge. But there was originally a theft that was attached.
Okay,
That's what it was.
so that's a previously ordered restitution to be paid
I
at.
didn't recall that. I didn't tell Mr. Frank.
Well, do you want to, Mr. Fayette's indicating he can typically get things very promptly from this family. I don't know if you want to include that or how you want to proceed, Ms. Farrell.
Your Honor, I'm gonna have proof of that case. I mean, that was the offer. that all restitution be paid in here, 1 year jail compensation.
If there's another 250, Judge, if you want to pass me, I can see if I can collect that right now. They've been paying me with a credit card. I didn't know of that amount, or I would have collected that yesterday.
Yeah, I understand. Is he getting out today if he gets this?
He's not. If you want to reset it, he is not getting out, but he has about 40 days left as of today with his credit. So if we did it next week, we can do that. It's up to you, Judge.
Well, I'm fine. I think it's sounding like that does look like a very big office, Mr. Darrow. It sounded like the state would be more comfortable if you had that in hand. So
That'd be fine.
Ms. Farrell, is it 250 for sure?
Yes, sir. I previously ordered it. I did check card, no payments.
If Ms. Farrell gets me the addresses of where I need to send this stuff, I'll even have the checks out by next week. I'll collect it today. I'll send the checks out tomorrow.
Okay. Yeah.
These are all the restitution.
Yeah, everything will be in showcase, Mr. Fayette. This is in 19 CF 744, restitution of Patrick Flannery of 250. So around January 16, 2020 should be a restitution order in showcase.
Okay.
And so I think that's going to have the address and everything. But if you want me to roll this 1 week or 2?
I think just one, Judge. I'll get it. Family's anxious to have it done, but I'll call the family now and collect that again. I apologize. I did not know of that 250. I didn't catch that part.
That's okay. It sounds like an honest, just a miss. But I think state's wanting to confirm that it's paid. So if you are able to get all of that satisfied and confirm to her that it's paid, if you think a week is sufficient to do that, then I'm happy to set you to the 4th, or we can go to the 11th. Either way.
No, next week I'll have it done, Judge. I think I'll have it done within the hour.
Okay. All right. I'll just ask you to keep Ms. Farrell posted. Mr. Burke, we just have that other case. Obviously, you've been able to hear all that. We've got.
Is there any way to get a release date today?
There's no, can he hear me? Mr. Burke, can you hear me?
Yeah.
Mr. Burke, this isn't going to change your release date. I understand that you got to get that. If you tell them they can wait, I can get them the credit, or if they want to call my office, but the other week is not going to change your release date. You will be out for that follow-up care within the time frame that they're asking, and if they question that, they're welcome to call my office.
Well, they said that it has to be in the computer system here.
I understand that, but I can't do anything with it. We missed the other restitution stuff, but I can't see a week being something that they're gonna hold you to it. He's concerned, Judge, about there's some aftercare that he wants to participate in, and they need to know a release date within 40 days of his release. Not that necessarily makes sense to me, but again, I'll follow up with that.
Okay, I think I understand, and there won't be a formal release date until he's sentenced.
Okay.
Right? So he wants to get sentenced so he can have a release date that is known, and there isn't one until he gets sentenced. Okay, well, I'll set it, I'll roll the case 1 week to February 4th, and let Mr. Fayette do a little bit of legwork to get both of these restitutions paid, and then we'll look forward to resolving things for you next Thursday morning.
Okay, thanks for your time, Judge.
Okay, thank you. All right, so February 4th, please, Madam Clerk, on both of those.
I think that is one bottom of page 318, 49, bottom of page 419.
Okay, and I have an old docket. Byers has already come off the docket, right? Okay. All right. Okay, Ms. Druin, good morning. Okay, represented by Mr. Darrow. Mr. Darrow, do you want to update us on Ms. Druin's situation?
Yes, Your Honor, we had staffed her on Tuesday. The team was not willing to go to the 28-day program. We have several other potential programs in line. I've also been talking to the state about other potential resolutions. I would ask that if we go out 2 weeks, we should hopefully have a plan firmly in place by then.
Okay, requesting that February 11 date.
Yes.
All right. State have anything to add to that? Ms. Druin, could you hear Mr. Darrow okay?
Yes, ma'am.
Okay, so that's what we'll do then. We'll go to February 11th and give them a few more weeks to figure out what your options are going to be on this, okay?
Great, thank you so much.
Okay, thank you, Ms. Druin. Good luck.
This is Michael Air, bottom of page 6, 18 CF 676, top of page 7, 19 CF 169, bottom of page 7, 19 CF 12.
Okay. Good morning, Mr. Hare.
Good morning, Your Honor.
And I don't show Mr. Hare represented. Is he represented by you all, Mr. Darrow?
So that's for some reason I'm showing on one case and not the other. I haven't
Okay.
had a conference with him, but it's my understanding based on previous reports and what we talked about that everybody's on the same page. When Crossroads, I think there's not status as far as when bed spaces can be available.
Okay. Mr. Hare, did you get screened yesterday?
Yes, ma'am, I did.
That was our, when the team spoke on Tuesday, the expectation was screening Wednesday and court Thursday. So that's good. We're on track there.
I'm approved too, so I said, of course, February 4th, we opened it.
Okay. Yeah, I had first week in February in my notes, so that sounds like that may be likely. So do we want to set Mr. Hare to February 4th, or we can just go to February 11th? You're going to give me an order whenever we've got a bed date.
Let's go to the 11th. Yeah, as soon as I hear that there's bed space available, we'll get your order, get it out.
I'd prefer that, because if he's got court on the 4th and they want him on the 4th, it's going to screw them all up. So we'll do that, Mr. Hare. I'm going to give you a court date February 11th. You should be out of my jail by then. I don't need you to be in court. We'll take care of it. We just are keeping our foot in the door, more or less. Okay. Let's just fix that volume issue. Okay. So what's going to happen from here is your attorney will get me an order once we get an actual date and time from Crossroads, and we'll do an order that will release you on that date to get over to Crossroads. I believe we're talking about a case manager giving him a ride over, or somebody from DLC. So you'll be released to DLC. They'll transport you over to Crossroads and you'll get it done over there. Okay. And we'll worry about everything else after that. I just need you to focus on getting everything you can out of Crossroads. It's a phenomenal program, tremendous resources, tremendous information and opportunity there for you. I know you've got a good attitude, you always have. So put that attitude to good work, keep an open mind, and let them teach you what they can teach you. And hopefully our goal is to help you be able to manage the tough times more safely so you don't end up in this situation again, okay?
Okay, sounds good.
Do you have any questions?
No, I'm still looking forward to my progress about the doing, so we understand. I still got to focus on like I said before, I'm taking everything off.
Okay. Okay. Well, I think that's good. I won't get a chance to talk to you more than likely before you actually go, but I'm excited for you to go. I will get status reports, and something they just started doing in the last few weeks. It'll probably be Brooke, I'm guessing. Brooke or James will be touching base with you throughout your time there, and they're going to report back to the team on how you're doing. So I look forward to getting good updates that you're making good progress and really giving the effort, okay?
All right.
Very good, Mr. Hare. I'm excited for you. Next time I see you will probably be when you're completed Crossroads. So good luck. Keep that focus and that good attitude.
Thank you.
All right, so February 11th, we'll status Mr. Hare's case, please.
And finally, from this, this is going to be Joshua Weaver, bottom of page 10, 20 CF 716, 11, 20 CF 734, 24.
Okay, Mr. Weaver, good morning. Mr. Weaver, I signed an order from the public defender this morning advancing the process of getting you into a treatment program. Mr. Darrow, do you want to update us on that?
We're looking at first steps in Sarasota, and I think there's a March. We're looking at a March bed date. I talked about that. I believe I represented very positive attitude.
Great.
Let's get forward with treatment.
Okay, wonderful.
So we're hoping we can advance it faster than that, but
Do you want to touch base on something like February 25th?
yes.
Okay, and of course, I can always do an order sooner if we get a bed sooner than that. Mr. Weaver, I was really pleased to hear the update from your attorney that you seem to have your head in the right spot. You're ready to get to work. Is that accurate?
Yes, ma'am.
Okay.
I want to apologize to you because I pretty much didn't do anything I was supposed to with my groups and everything like they gave me. The gentlemen that were in my group, they had given me the tools to not do what I did. And the last thing I did was call them, and, so, and I was looking forward to meeting you on the polar punch, and I didn't get the chance to do that. So,
Yeah.
but I really apologize, honestly, for taking full responsibility for my mistake.
Well, I appreciate that, and I really have a lot of respect for your courage and your attitude to hang in there and keep your focus and accept a second chance. You got to be patient. It's costing you a little bit of time, but I think you were buddies a little bit with Court Gonzalez. Is that right?
Yes, ma'am.
He said something to me when he first got out. He said, Judge, I used my time in jail really well. He said he used the time to just get himself focused, and he expressed concern, by the way. He said he was heartbroken that you were suffering and going through what you were going through before you came into custody. But the guys are there. They are really excited to help each other out. I have never seen a journey yet that went in a perfectly straight line. Sometimes they zig and they zag, and that's what's going on for you. But it's far from over, and a lot of good stuff lies ahead if you hang on to that attitude and that open mind, okay? Good. Well, I appreciate Mr. Darrow's team. They've been working really hard. We're hoping maybe we catch a break and get an earlier bed for you, but just make sure you're ready when you go. I'll give you that February 25th status date, but Mr. Darrow can send me an order literally 24/7. If he gets a bed date, we can mobilize. So if I don't get a chance to talk to you before we catch that break, you know what you need to do.
Yes, ma'am. Thank you again.
Okay. All right. Well, Mr. Weaver, I'm excited that you're looking to take the opportunity and continue to work with us. And I'll see you February 25th if we haven't already gotten you a bed.
Okay, thank you.
Good luck.
And I saw 5. Top of page 9, your labor 20 MM 931.
I forgot my readers yesterday about 10 o'clock. I had to go to Walmart. So
I have the opposite problem. I can't see you guys, but I'm okay reading. Okay, Mr. Leyva, are we pronouncing that correctly?
Yes, sir.
Okay, good morning, sir. All right, Mr. Leyva's with us on 3 cases then. It looks like 2 are violation of probation and 1 is a new misdemeanor, first-degree misdemeanor. Do I have that right?
Yes, sir.
Okay. Mr. Leyva, I'm going to ask the state attorney to go through the terms of your offer and let us know if at any point there's any of us that you can't hear clearly. She'll go through that. We'll make sure we're all on the same page and we'll get going, okay?
Yes, you said first-degree misdemeanor?
First-degree misdemeanor, petty theft, second offense is what I'm showing. Is that what you all have?
Yes, sir. That was because of the file of the reduction from the one that resulted in violation.
So it may have started as a felony. It ultimately got dropped down to a misdemeanor, that new charge, but all of them are big enough to violate the felony probations that you were on. And I think it's going to be the probation that's going to bring you into drug court. Does that make sense?
Yes, sir.
Okay. Okay, let me ask the state to go through the terms.
Now, case number 18 CF 1886 and 19 CF 150. That is going to violation of community control. The underlying charge in the 18 case is a plea with a law enforcement officer. The underlying charge in the 19 case is possession of cocaine. Consideration will be revoked, community control will be revoked in both cases. It was previously adjudicated. In 18 CF 1886 will be sentenced to 3 years of state probation, the first 2 of which will be drug offender probation due to the fact that it's having a time left in the school year.
Okay.
That will run concurrently with 19 CF 150, will be sentenced to 4 years, and 19 CF CF150. First two of which will be during the penal probation, the 18 CF case.
Okay.
All terms and conditions of probation in both cases are the same, meaning he shall enter into successful drug court, following all treatment recommendations, 10 p.m. until 6 a.m. curfew, unless that is modified by the court of probation. Attend recovery support group meetings as directed by treatment, and if directed to do so, submit critical reaction sheets to the case manager as directed. Follow all recommendations of this clinical assessment. Be subject to testing for alcohol, controlled substances, and unapproved medications by both treatment and probation, and a minimum of 2 times per week between the two testers at his own expense. Now, this is a little bit unusual. Mr. Latham has made a request for accommodations in relation to urine screens.
Okay.
I've spoken to both treatment and probation. They have both agreed to do that. That relates to observed urine screens.
Okay.
In his contract, it specifically states that those accommodations are going to be made, but that the defendant is then not going to be allowed to turn around and say, because it wasn't observed, it doesn't belong to me.
Okay.
He's waiving his right to argue that any sample he provides is not.
Okay.
That's in the
That's
contract.
correct.
That seems abundantly fair.
This is a long path to get here, but I think we've got a good solution.
Well, I very much appreciate the diligence both of you probably had to put in to get us here, so thank you. All right, and the way you've worded that, Ms. Farrell, because I know we talked about this week at staffing, so it'll be a minimum of twice a week, and DOC and DLC can sort out how they want to do it,
Yes.
which so far has meant that DOC is just going to insist on doing twice a week, and there may be redundancy. You may be dropping a test twice in a given day between probation and treatment. You understand that? You with me, Mr.? Okay. Okay. All right, go ahead, Ms. Farrell.
In the last condition for possession of consumption of alcohol, go frequent any places that primarily sell or serve alcohol. $100 cost of prosecution on both cases, and all previously ordered costs will carry forward. There were no other terms of condition. Terms of probation that's going to carry forward. And Your Honor, in the misdemeanor case, 20 MM 931, the terms of the plea were adjudication of guilt, time served, and a no trespass in the 7-Eleven store at 1871 Pine Ridge Road in Naples. And I have an order for that. There's no rest.
Okay, and I would be giving 90 days to either pay or set up a payment plan with the clerk on that, since that will be in probation. Okay. All right, Mr. Darrow, was all of that consistent with your negotiation?
That's not-
Mr. Leyva, did you understand everything the state attorney just explained to me?
Yes, Your Honor.
Do you want to accept those terms and resolve all three of these cases this way by coming into drug court?
Yes, Your Honor.
Would you raise your right hand to be sworn, please?
Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Okay, the state attorney is going to ask you some questions. You can put your hand down.
Sir, can I please have your full name and date of birth?
You want the label, 11/1990.
What are the last 4 digits of your social security number, please?
9427.
Okay, Mr. Labor, where were you born?
Cuba.
And how far did you go to school?
10.
Do you have any difficulties reading or writing the English language?
No, ma'am.
At this time, are you under the influence of any alcohol or non-prescribed medications or controlled substances?
No.
Are you taking any medication that is prescribed by a doctor?
No.
Do you suffer from any mental health issues?
No.
Mr. Labor, in case number 18 CF 1886, you were previously placed on community control for the charge of fleeing or eluding a law enforcement officer, is that correct?
Yes, ma'am.
And in case number 19 CF 150, you were placed on community control for possession of cocaine, is that also correct?
Yes, ma'am.
Were the terms and conditions of your probation explained to you both by the court and your probation officer?
Yes.
And I'm sorry, the conditions of your community control. Did you understand those conditions as described and explained to you?
Yes, ma'am.
If you admit to violating certain conditions of that community control, Namely, condition 5, by being arrested for a petty theft or subsequent on May 29th, 2020.
Yes.
And also conditions 16 and 17, by failing to comply with your submitted hourly schedule by being outside of the residence without permission.
Yes, ma'am.
Have you read a copy of an admission form?
Yes, ma'am.
You understand all the rights that you're giving up by admitting the student fact violation to the control today.
Yes, ma'am.
You understand that as a result of your admission, there will be no hearing, and the state will no longer be required to plead in fact violation community control by the greater weight of the evidence.
Yes.
You understand that there will be no witnesses called to prove the violation, and therefore no opportunity to question them for your attorney.
Yes, ma'am.
That you no longer have an opportunity to call any witnesses or present any defenses to your violation.
I do understand now.
You understand that by giving up your right to have a hearing, you will also give up your opportunity to present any witnesses or any defenses to your violation.
I understand.
You're also giving up your right to testify and tell your side of the story at the hearing. You understand that as well?
Yes, ma'am.
Have you had enough time to discuss this violation and all the rights you're giving up with either Mr. Darrow or your assigned public defender?
Yes, ma'am.
Are you satisfied with their advice?
Yes, ma'am.
You understand that you're being placed on probation now for 2 3 felonies. Should you violate the
Yes.
probation again, you could be sentenced up to 5 years in prison on each count, and it could run consecutive.
Yes, ma'am.
Have you had an opportunity with your attorney to go through your score sheet?
Yes.
Do you agree that it is accurate as to your prior criminal history?
Yes, exactly.
Do you understand that according to the Court of Sentencing Guidelines, the minimum permissible sentence absent your agreement and eligibility for drug court would have been 15.9 months in prison?
Yes, ma'am.
You understand that this score sheet will remain in effect throughout the court, meaning that if you violate again, you're going to score even higher than that?
Yes, understand.
Has anybody promised you anything other than the terms of the plea that you would make a violation of that?
No,
Anybody force you, or threaten you in any way to get you to prison?
no,
Are you in anything you believe is in your best interest to do so?
yes,
And you understand if you're not a U.S. citizen, these admissions could be used against you in deportation.
understand.
And also that if in the future you're convicted of any sort of sexually violent or motivated offense, that these admissions could be used against you in what's called an involuntary civil commitment proceeding if you qualify under the statute as a sexually violent offense.
Yes,
Finally, in case 2931 NF, you were charged with the case theft, second offense of the first degree misdemeanor that carries a maximum penalty of 1 year in the county jail. You wish to plead guilty, not guilty, and no contest to that charge.
no, no,
No contest, all right. Have you had also an opportunity to review a county court plea form?
yes,
You understand all the rights you're giving up by pleading to that charge?
yes,
Understand there'll be no trial, and again, no opportunity to question the state's evidence or the witnesses or present any defenses you may have had to that charge.
yes, ma'am.
And you talked to an attorney about that case and the rights of that case as well, is that correct?
Yes, ma'am.
And you understand that you were charged with an enhanced offense. You understand that based on your prior petty theft, you could again be charged as a felon if you pick up another petty theft or another theft of any kind.
Yes,
Your Honor, I would tender the open admissions for the commission.
Okay, Mr. Leyva, I have read your files. I find there's a factual basis for your pleas. I find that you freely, voluntarily, and intelligently waived your rights. You've knowingly entered these pleas with a full understanding of the consequences. So I'll accept your pleas and your admissions and will sentence you as follows. In case 20 MM 931, that petty theft new case, I'll adjudicate you guilty, sentence you simply the time you've already served. I'll order you to pay all mandatory court costs as well as $50 each for the cost of prosecution and defense. I'll give you up to 90 days to get those paid through the clerk or set up a payment plan with them. You're not on probation on that, so I can't give you more time. You'll just need to visit the clerk's office when you get a chance, when you get out, to get that set up, okay? I'll also, on that case, I'll also trespass you from that 7-Eleven at 1871 Pine Ridge Road in Naples. You can't go back to that location while you're on probation, okay? Yes, sir?
I can go to another 7-Eleven, like 2 gas or something.
Correct, just stay away from that one.
All right.
Okay, that's everything on that case. Do you have any questions about that case?
No.
Okay. And then with regard to 18 CF 1886 and 19 CF 150, almost the exact same outcome. I will accept your admissions. I'll revoke the probation or community control that you had in those cases, and will resentence you as follows. You're already adjudicated guilty on both, which Ms. Farrell means I think he's already suffered a loss of license on both possession and the fleeing. Okay. On the fleeing, which is case 1886, I'm placing you on 3 years state probation, with the first 2 being drug offender. In case 19 CF 150, I'm placing you on 4 years of state probation, with the first 2 being drug offender. All other terms and conditions are going to be the same for both, and they're both going to run concurrently. So it's a total of 4 years of probation. First, on each of those, you're going to have a requirement that you comply with and successfully complete the drug court program. That means that everything that you read in our handbook, everything I specifically ordered today, and everything the treatment team might direct you to do along the way, all of that's part of your probation that I will enforce. Do you understand that? Okay. The first thing I'll do is go over a curfew. I am going to impose a curfew from 10 p.m. to 6 a.m. every night. That means you'll have to be at the address that you register with probation, get home no later than 10 o'clock, and stay there all the way until at least 6 in the morning the next morning. We will have members of law enforcement and or probation coming to at random, unannounced, to check on you and make sure that you are there. Do you know where you're going to be staying when you get out?
Yes, sir.
Where are you going to be staying?
I don't know the address, but I have my mom's moved to a new house.
Okay. So you're going to, that's okay, but you're going to be staying with your mom, is that right?
Yes, sir.
Who else is in that house with the 2 of you?
My daughter, my son, and my dad.
Okay, your mom, your dad, and your 2 kids?
Yes, sir.
How old are your kids?
My daughter's 4 years old and my son is 8 years old.
Okay, very good. So I'm hoping that I can assume your mom and your dad are both very supportive of what you're trying to do here in drug court to get clean and stay clean. Okay, very good. Good. So you got to understand, your whole family just went on probation. You might have probation officers knocking on the door at 1:30 in the morning to make sure that you're keeping curfew. That might disturb your mom and dad, but they're going to have to understand that. Do you think they're on board? Okay. Now, what I don't mean is that they got to do your probation stuff for you. It's your responsibility, but their lives are going to have to be potentially disrupted a little bit while you get supervised. You need to make sure that you are able to hear the door and respond for those curfew checks, so that you're there and you're being held accountable for that, okay? Your probation officer has the authority to adjust that curfew for certain necessities. The most common one is if somebody has a job where they either need to leave really early in the morning or they're going to get home really late at night. We got a lot of people maybe work in a restaurant, they don't get off work until midnight. What you need to do if you have that situation, probation's going to explain their process. You make a request in advance and they can give you approval. If you get approval, just be very strict about the adjusted curfew time. If you don't get approval, if you don't get an answer back in time, keep your regular curfew. Do not adjust that, okay? You've got to have explicit permission before you change your curfew. Probation's going to explain all of that to you when you get out and you meet with them. But do you have any questions for me?
No.
Okay. The next thing I'm going to do is I'm going to at least give you the heads up that treatment may require meetings. That might be AA, NA, Celebrate Recovery, Smart Recovery. They're going to go over all the various types of peer support group meetings that there are out there. And treatment, as part of your treatment plan, may recommend that you attend a certain number of those each week. They may also require you to write up a short statement after each meeting to document what you've done. And if they do that, you're going to have to be truthful and follow through on everything they're recommending. Do you understand that? they'll work with you to figure out what's a good fit and so forth. It's part of your treatment plan, but I give you the heads up when I sentence you. The next requirement is that you're going to have a clinical assessment and follow all recommendations for treatment. You've already had that assessment. Do you recall doing that by video screen?
Yes, ma'am.
Okay, good. So we've already got our initial game plan for your treatment based on that assessment. And it'll be your job to follow anything and everything that they request that you do. That assessment is going to be an ongoing process. They will redo that assessment periodically throughout your time with us so that we get an accurate snapshot, because your needs are going to change as you get treatment, as you get stabilized and so forth. So understand that it may change from time to time, but your obligation will stay the same, which is to follow everything treatment requests you to do. Do you understand that?
Yes, ma'am.
Every now and then I get somebody who comes into one of our treatment courts and then says, I didn't want to do treatment. You're signing up for whatever treatment they recommend. And that may include, you've indicated that you don't have a mental health history, that you're not on any prescription medication. But when you get into working with the experts at treatment, if they see something that causes them to question whether you might need support for mental health or you might need a medication, they will make referrals to you either for possibly another part of David Lawrence Center or possibly an outside provider. You will also have to follow through on those referrals and then follow whatever is recommended. Do you understand that?
Yes, ma'am. I'm willing to do that.
Good. I'm happy to hear it. Our goal is to take care of the whole person, Mr. Leyva. So we're not just here to try to keep you clean. If there's a mental health need, we're here to address that. If there's a medical need that maybe you've been neglecting, we're here to help you address that as well. I had a guy a few months ago had terrible stomach pain, and we required him to go see a doctor about his stomach pain, because that's part of, if you're going to stay clean, you got to take care of yourself. So all of that is part of what you're signing up for. We're going to do our best to help you be healthy and well in the complete sense. Do you understand?
Yes.
Very good. All right, now I'm going to go over a sobriety rule with you. You can't possess or consume any alcohol. You can't have any alcohol in your home. You can't go to any bars or places that primarily make their money from alcohol. You also can't possess or consume any drugs, any unapproved medications, or any mind-altering substances. You're going to be drug tested at random throughout your time with us, and pretty constantly, especially at the beginning. We're going to require that between David Lawrence and probation, that they ensure that you are drug tested at least twice every single week. We have noted that there will be an accommodation based on what I assume is probably a medical suggestion that's been documented. And so they will follow through with that and deal with that as has been discussed with you. But it will be at least twice a week, possibly quite a bit more than that. When you're called in, you've got to report promptly and follow through with that. Do you understand that obligation?
Yes,
Let me go through the sobriety rule in a little bit more detail. No alcohol, no drugs, that's pretty self-explanatory, but I want to go over the other two parts. No unapproved medications means a few things, and it's written out pretty well in the handbook, I think, but I like to go over it as well. You said you don't currently have any prescription medication, and that might stay true the whole time we work together. But if you end up with any provider looking to prescribe medication for you, there are some rules. If it's a David Lawrence Center provider, our team's going to be aware of that pretty immediately. But you also probably want to mention it. Hey, the guy at main campus just put me on such and such. And if that happens, you're to take it as prescribed. We'll simply enforce the doctor's orders. So you don't take more of it or less of it than you're supposed to. Don't let it run out if you're supposed to refill it, and stay on it. Keep up with any follow-up appointments that they direct you to make, and so forth. Don't ever share your medication with someone else, and don't ever take somebody else's prescription medication. That's actually its own felony, okay? But mainly we want to make sure that you follow those instructions. The other part of the rule is this: if any outside provider wants to put you on a prescription medication, we're going to require you to notify your case manager right away. We recommend, if it's not an emergency, that you actually talk to the case manager before you purchase that prescription or consume it. But if the circumstances, if you're in the ER or something like that and they're administering it, okay. But as quickly as possible, you need to let your case manager know, hey, this person's prescribing a medication to me. Our goal there is to try to make sure that another doctor doesn't undermine what you're trying to do here in drug court. So you may or may not be aware, there's doctors all over this town that right now would write you a prescription for painkillers or Xanax or Ritalin or whatever you might think you might benefit from. Obviously, we would prefer you not be on those things. That is going to take you out of a clean lifestyle. So we're not here to interfere with your medical care. We want you to get what you need from appropriate physicians, but we're going to be extremely nosy. And we're going to demand that you let us know right away. You might have to sign releases of information. We're probably going to talk to that doctor or that doctor's staff to find out why they want to put you on this, whether there's another medication that'll work just as well, it's not narcotic, etc. Okay? You should, from this point forward, even when you're finished with drug court, you should get in the habit of anytime you've got to go consult a doctor, if they want to put you on anything or perform a procedure, that you let them know, hey, I'm in recovery, so I need some special consideration, so they don't load you up with a bunch of hydrocodone needlessly. A doctor might want to pull a tooth or something. They're ready to give you Vicodin before you even get started. Xanax too, I heard recently. You need to say, hey, look, can I do Motrin? Can I do something else? I'm in recovery. Okay, that's part of you just being smart. But you also got to clue us in so that we can be on top of that and make sure we're assisting you. I have had so many guys in drug court doing so well until maybe they get hurt at work, they go to a walk-in clinic, they get a prescription, and man, now they're driving off a cliff. So we're going to be in your business. Do you understand how that rule works? Anything's going on, even an antibiotic for a head cold, I want to know about it as soon as they prescribe it. All right. Any questions on that?
No.
All right. The final part of that was no mind-altering substances. That's a catch-all for everything else. So as it says in the handbook, we're going to prohibit you from using any of the designer drugs that are out there, things like spice and bath salts and whatever they might invent tomorrow. Some of that is technically legal, some of it is illegal. Doesn't matter to you, it's all illegal for you, okay? If it is designed to help you relax, help ease your pain, help you sleep, make you less anxious, help you focus, all that stuff is mind altering, and you want to check with your case manager before you consume anything that anybody's suggesting might help you, all right? So designer drugs, another category is the herbal stuff that's out there. We've got things like kratom and kava. Those are currently legal in Florida. They're illegal in some other states. They're illegal for you, okay? You cannot consume those. We can and do test for those. And if it's in your system, you'll be held accountable. So be careful. Certain things at the health food store right now have kratom in them. You need to be able to check ingredients. Check with a case manager before you take any sort of herbal remedy, any sort of supplements, etc. Okay? Is that anything that you had done before? Did you use any kind of herbal remedies or anything that you're concerned about?
No, usually my drug choice is Christmas.
Okay. All right. So stimulant. Okay. Very good. So just make sure that you're careful not to consume anything that's got any of those ingredients. The last part of the rule is, the last part of what we consider in there is stuff that you can get at the grocery store or the pharmacy. Certain cough and cold medication. There are other over-the-counter medications that do also contain some stimulant drugs. So all of that is out of bounds unless you have permission from treatment. Treatment's going to give you a list of everything you can safely take for common ailments like a head cold or a minor injury, etc. They'll let you know what you can take. Anything else, ask your case manager before you spend the money to buy something. You can pull it up with Google and they can check it out for you and make sure that it's going to keep you from having a positive drug test, okay? Do you have any questions about any of that?
Yes, I heard about food, there's some kind of seasoning, because in food that it will show that like drug in the system.
Yeah.
in the probation officer, writing like this or the name of whatever can I can take in like the rational ending.
Yeah.
Am I right?
Yes, and they're going to go over that when you go through orientation. I think what you're probably referencing is a poppy seed bagel. That's everybody's favorite. Supposedly, poppy seeds will show positive for opioids. I haven't seen good evidence of that yet. You got to eat about a truckload of poppy seeds to have that show up. It's a lot of bagels, but we will, huh?
Just making sure.
Yes, we've got that in the handbook, and treatment will go over that as well. If I were you, I just wouldn't eat poppy seed bagels and so forth and just stay away from it so you don't have anything to worry about, okay?
Yes.
Good. Any other questions about that sobriety rule?
No, I was not yet.
Okay, we're getting close. Then I just will, in each of these violation cases, impose $100 each for the prosecution and defense. And I will carry forward any financial obligations that ran with those two cases from the original sentence. Okay, let me switch to the paperwork here. Some of this is just stuff I've got to sign. So I'm signing the no trespass order on the 7-Eleven, that particular 7-Eleven. The score sheet, Mr. Darrow, let me just review one more time. I'm showing a score sheet with 49.2 total sentence points, and that's translating to 15.9 months as the lowest permissible prison sentence, 10 years as the maximum. Is that what you all reviewed? Do you have any objection to the court accepting and relying upon that for his admissions? And do both sides agree this is an appropriate departure downward based on Mr. Leyva's appropriateness for and willingness to participate in our drug court program?
Yes, sir.
Okay, and I'll indicate that. Okay. All right, Mr. Leyva, the main reason I go over that score sheet, you've got a probation outcome today, and you were probably aware that you were scoring to at least 15.9 months in prison all the way to 10 years, right?
Yes.
And so Florida law supports drug court. And Florida law says, even if somebody scores out to minimum prison time, we're going to let you give them a probation outcome if they want to do drug court. So you've got a great opportunity here today to walk out of that jail in a few days and never do another day of jail or prison in your life. But you need to understand that these penalties are going to hang in the background while we do our work together. And you came to me on a violation, so I know you understand. If you come back on a violation, you're going to have points added. And if the state attorney is able to prove a willful and substantial violation, then you're going to probably be looking at closer to 2 years on the low end, 10 years on the high end. That's going to be what's hanging in the background while we work together. Do you understand how that works? Okay, very good. I hope never to discuss it again, but I always want to make sure that people understand the stakes are high all the way until you successfully complete the probation. And that's what your attitude should be, okay? All right, next I'm going to sign an order that sets your probation fees at 0 for the period of time that you are in the in-court portion. So basically that first year of drug court, your probation fees will be set at 0. So that'll free up a little bit of money for you to pay for treatment and other things that you're obligated to do. I'm also going to sign an order that allows the team to discuss limited healthcare information for you. Basically, that allows David Lawrence Center and probation to let us know, are you showing up? Are you participating? Is the drug test positive for any substances? That's it. I don't ever need to know what you actually discuss with your counselors. That's confidential between you and your counselors. We're simply going to get the information to confirm that you're complying. Do you understand how that works? Okay, and then among us as a team, we will keep that confidential and we won't share it with anyone outside of the team. I'm looking at your drug court contract, Mr. Leyva. 3-page contract that looks like it's got a signature from you from a couple of weeks ago, back January 14th. Did you go over this carefully with your attorneys?
Yes.
Did you understand what you were agreeing to when you signed this? Do you have any questions you want to ask me or your attorney about the contract or anything else that we've discussed?
Okay, I understand.
Are you comfortable that you can do all the things that we've discussed and that are spelled out in this contract?
Yes, ma'am.
Okay, very good. You'll have all kinds of help to help ensure that you do this. All of us are committed to your success, but I want to make sure that you're not walking into something that you already think is going to be a setup for you. You think you can do this?
Yes, ma'am. This is what I want from the first day I came to jail.
Excellent. Excellent. Well, we're excited to get to work with you. It looks like paragraph 4 of this contract is the part where the state attorney has made a promise back to you. And what she said is that when you successfully complete drug court, which is that first year, and then aftercare, which is basically the second year, your probation, you get everything paid, you finish everything, that you're going to be able to ask me to terminate the case early, terminate your probation early, if you get that done in less than 4 years, actually 3 years on the one case. Do you understand that that's the promise?
Yes, ma'am.
When I agree to grant that, then your probation will be terminated on both cases. You'd be finished with your obligations to the court and be on your way. Is that your understanding?
Yes, ma'am.
You know that you have felonies on your record and that there are no charges being dropped as a result of this plea.
Yes, ma'am.
Okay, very good. So we're all on the same page there. I'll sign off on that contract. And Mr. Leyva, I forgot to ask you or verify, but I'd like to now. You're with us by closed circuit TV. Normally, you would be standing here in the courtroom with all of us, but with the pandemic, we've had some different procedures. Are you comfortable proceeding the way that we have been this morning?
Yes, yes.
Okay, have you been able to hear and understand everything we've been talking about?
Yes, ma'am.
And I didn't mention this at the beginning, but I will now. Your attorney's in the courtroom. If any question popped into your head and you wanted to speak privately with your attorney, we could stop and I could make that possible for you, no problem. So please speak up if you do have any questions, okay? Do you want to waive any objection that you would potentially have to proceeding by television as opposed to being live in the courtroom in order to get this done today instead of waiting until the end of the pandemic?
No.
You want to waive that objection? My question was goofy, I'm sorry. Are you comfortable proceeding by television today?
Yes, yes, okay.
Okay, all right. I think the last thing I've got to go over then is your release. This is the best part. I always save it for last. Looks like Monday morning at 10 a.m. is our proposed release time for you to be released to one of the case managers from David Lawrence Center. They'll take you over to probation and then take you to whatever they need you to do. You'll be with them probably most of the day on Monday.
So on the first someone will pick me up on the jail.
Yep, they'll come get you directly from the jail. So about 10 in the morning, they'll pick you up and they'll, like I said, they'll be running you around to probation, David Lawrence, orientation with everything. You'll be pretty busy for Monday. So you don't need to have your family get you at the jail. And you also should tell your family that you're going to be tied up for a little while. Once you get out, your case manager will help you get connected to your family and everything else, okay? All right, so I will sign that. And while I'm doing that, I think I've got one or both case managers. Mr. Monplaisy, anything that you wanted to add from treatment in terms of any instructions for Mr. Leyva? I'm not positive if he's sitting at his desk. Yes.
Not at this time, Your Honor.
Okay, very good. All right, so treatment's all set. I think all I need to do, Mr. Leyva, is just go over a couple of rules with you and then we'll be finished. The first thing I wanted to tell you is just some manners that we require in drug court, and they're in the handbook as well, so you've seen this. But while you're in court or in treatment, we demand your attention and that you be respectful, okay? So when that's in person, it means you're not gonna have your phone on you. You'll turn that in, not be distracted by your phone, not be talking to anybody else, but be paying attention to what's going on in treatment. or in court. For some of the things, certainly for court, and I think some of the treatment, it's going to look like this. It's going to be done on a video screen. So you might be at home. You definitely need to be someplace where it's quiet, where you have a good internet connection, where you can speak confidentially with treatment. You need to have no distractions. I don't want you eating, drinking, smoking, vaping, no pets or kids running around distracting you. You know, if you're at home, what works best is to, you know, maybe go into a room where you can close the door and you can speak privately and you can listen and pay attention and focus, okay? Treatment's going to talk to you when you get out and figure out, okay, what do you have? What do you need to try to make sure that you have access to a quiet, comfortable spot where you can attend court and treatment like I've just described. And then when we get past this pandemic, you'll be showing up in person to your treatment appointments and your court appointments. And it's probably a little easier to behave there, but you've got to remind yourself when you're home, maybe you've got a treatment session, I want you to behave exactly the same way you are now. Exactly the same way you would if you were sitting here in the courtroom with me on the bench. You wouldn't be talking, you wouldn't be distracted, you wouldn't be taking phone calls or any of that. Just focus on what's going on. And if you're having to attend with a cell phone, which most of our guys are, they're using the cell phone for their video conference. If calls are coming in or text messages are coming in, you got to ignore those. I had one guy this week, we told him, you got to use the setting that shuts all that down because it's too distracting. So whatever treatment tells you to do in that regard, follow through with it. Your ability to focus, be respectful, and pay attention is very important to what we're trying to do. Do you understand all that? We do also have in the handbook a dress code, nothing fancy, but we do require that folks be dressed respectfully. So you're not going to be in t-shirts that say stuff, just usually a simple collared shirt. We can help you get one if you need help. And when you're coming to court, long pants, no flip-flops, no shorts, no t-shirts, etc. Okay, so treatment will go over all that with you as well. But we do have some rules to make sure that guys are showing respect for themselves, for each other, and for the treatment team and the court. So make sure that you're familiar with those and that you follow those, okay? Respect goes a very, very long way with me and with our team. And then the last thing I want to go over with you, and then I swear I'll let you sit down. The last thing is the most important thing. And the only thing that you really have to be sure that you remember about all the stuff I told you. Honesty is the key. It's written all throughout our handbook. We try to make that point from the very first minute that you start thinking about drug court. The only thing you have to do perfectly is be honest. You were in there this morning with a few of our folks who are currently in drug court. Did you know that?
Yes, ma'am.
And I don't know if there's any chit chat or if they talk to you at all, but off the top of my head, I can think of a few of them, maybe even all of them. They're in there because they weren't honest. They might tell you that they're in there because they relapsed, and that's not accurate. They're in there because they relapsed and they didn't tell us about it. If they had relapsed and told us about it right away, they would not be in that jail. Honesty is the key to success in drug court. If you can only do one thing perfectly and just be honest, I'll tell you right now, you're not going to go back in that jail, okay? Not for anything involving drug court. So here's how we deal with honesty. On the front end, I want you to be honest about preventing problems. Let us know if there's something that's got you stressed or worried or overwhelmed. Maybe, one of your parents is giving you a bad time and it's hard at home. An old relationship is giving you a hard time. You're having a hard time finding work. Whatever it is, speak up. We don't have a magic wand, but we can help with a lot of stuff. And if we know that you're dealing with something, it helps us adjust the way that we support you. So clue us in ahead of time. It's the best way to avoid a problem. Let us help. Be honest about what's going on. And that includes if you're having cravings. If you get out and you're really struggling not to use, you're having a lot of cravings, a lot of obsessive thoughts about using or having a hard time avoiding triggers, you got to let us know because we can help with that as well, okay? You're in a different kind of court. You've been in court before, you've been on probation before, even community control. This is different. Forget what you think you know. Being honest about what's going on is the best way to stay out of jail. I know in the old courts, being honest is a terrible idea. Nobody's ever going to be honest on regular probation because it'll land you in jail. Flip that over, okay? Honesty is the best way to stay out. If you're not honest, that's how you end up back in jail. So tell us what we need to know to prevent problems. And if you do have a problem, if you do make a mistake, if you miss something, you oversleep, you forget to make a phone call, if you pick up and you use, whatever the mistake is, you need to pick up the phone, call your case manager, and own it right away. If you do that, then we're going to be able to work with you, and I won't have to put you in the jail. It's where people don't do that or wait until they're being handed a drug test to tell us, oh, by the way, I used last night. I think that test is going to be positive. That's where we start to have a problem. I need you to be fully honest and promptly honest. So if you pick up on a Tuesday night, you need to be calling your case manager first thing Wednesday morning to say, here's what happened. And then we'll regroup. We'll figure out what we need to do to help you with that, but I will keep you in treatment and not in jail. Do you understand how that works? Okay, very good. That's the main thing I need you to be thinking about for the next few nights that you spend in there, is how you're gonna walk in the world as an honest human being. And if you can just do that, everything else can be a work in progress. Everything else, we're gonna have some ups and downs and we can deal with it as long as you're being honest. Do you have any questions about anything I've gone over? Okay. All right. Well, Mr. Leyva, I'm excited to welcome you into drug court. I do know it's been a long road for you to get to this point. Monday morning, we're going to start moving things forward for you. And I'll see you Tuesday afternoon for your first session of drug court. It'll be like this on a video screen. Okay. Okay, Mr. Leyva, welcome. Okay. I've got into judgments. Okay, let me do that. That's fine, yeah. And Madam Clerk, if you are able to scroll up to the top, it's sort of mid-page. Okay, so this is the 150 case first.
Are we done with this attorney?
I'm reviewing his judgment, so I need him to just be within a earshot and make sure I don't have any other questions that pop up. So I'll stay on the record and on the jail for just another moment. You all can do fingerprints if you need to. I just want to keep the connection open in case I come up with another question for Mr. Leyva.
Yes, sir.
Thank you, Mr. Leyva. Yeah, if you just keep us connected. Okay. Okay, if you want to scroll down, please. Okay, good. Okay. Okay, if you want to scroll down one more time. Okay, I approve all three. Thank you. Anything else we need to discuss on the record? Okay, all right, we're all set. Thank you, Jail.
Jail will stand by for the other two defendants.
Oh, okay, that's right. We do still have two more. I always do the pleas last, so I got excited, Lisa. We're going to have Ms. Franklin and who else? Okay. Okay. All right, so I think Madam Clerk, are you ready for the next one? Okay, very good. The state can resume calling the docket.
We can call Andrea Lopez, 18 CF 2105, bottom page 9, page 10, 19 CF 105.
Okay. Okay, Ms. Robles, good morning. Ms. Robles is with us. We had a report, if I'm recalling correctly, that we had a report of a positive drug screen. And so a violation of probation warrant was drafted, signed, and served. Mr. Darrow, are you all on board, or do I need to make a temporary appointment?
It's that I represented her before, so if we're not showing, this happened so quickly. Judge, since it happened Tuesday, I have not had an opportunity to schedule a visit with her.
Okay.
So, and she was in the other room this morning, so I haven't spoken to her.
And Ms. Robles was a public defender client, so this will be one that you'll just simply do a notice without an application.
Yes.
So, Madam Clerk, I'm going to make a temporary appointment on both of Ms. Robles' cases for today, and Mr. Darrow will be getting us into his appearance. All right, and Ms. Robles, we understand because this has happened so quickly, the attorney's not been able to speak with you. I imagine treatment's not been able to speak with you either yet. Mr. Darrow, do we want to just go to next week's docket and then we can have?
And I've actually tried, made an attempt to set a jail visit with her, but she's showing it's restricted. I don't know why. I'm trying to go the next couple of days. There may be some problems.
I would assume for the first 2 weeks people are in, they're just in quarantine and it's tricky.
That it's a possible explanation, except I see people that go in all the time.
Okay.
I'll give it another day or two, and then I'll go ahead and set it through I'll set it through jail administration. Try to set it through jail administration so that I at least speak to her before next Thursday.
Right. Yeah. I know re-entry or jail admin will likely help.
They usually will set things up for me if I can't get it going. I just don't like to bother them until I give it a day or two to make sure it's not just a snafu.
Okay.
I tried yesterday and today to set appointments.
I appreciate that. Ms. Robles, Mr. Darrow is going to try to connect with you to speak with you, and I imagine it's possible treatment may be trying to connect with you to speak with you as well. I'm simply going to reset this to the same time next week, which will be February 4th, and the team will staff things Tuesday morning as we always do. So Mr. Darrow will be representing you at that staffing and so forth, okay? If there is anything that you need to get to him before he's able to see you, you can write that up, and I think we can get through reentry, Mr. Darrow. We could get that to Janice. So if you want to communicate with him or there's things he needs to know, feel free to write that up and direct it to your attorney. The reentry team can get that to us. It'll go to Mr. Darrow, and he can share it with the team if he thinks it's appropriate. Okay?
Okay, yeah, my only concern was like my rent and stuff. I have a lot of things, unfortunately, that I've built over this year now that I'm worried about losing, like my apartment, my car. So my rent usually due on the 3rd.
Okay.
I have no way of contacting my landlord to let him know I'm in custody.
Okay. I don't have good answers for any of that for you. I don't know if you've got anybody on the outside who can assist with that. I don't have a solution to that. So you're gonna be with us for a week unless something changes. Like I said, we'll be speaking on Tuesday, which will be the 2nd. So you may want to try to get a written communication. I really don't want you to say anything about what has or has not happened until you speak to Mr. Darrow. But if you want to write anything up for him, you can get that to him. And if it's anything that he needs to share with us, he can. Okay. Ms. Robles, I will see you next week then. Thank you.
Okay. We have Patricia Franklin, bottom of page 4, 16 CF, 1830. page 5 as well, 16 CF 1839, 16 CF 1846.
Okay,
I think am I showing as counsel for her or?
I believe you are on my docket.
Judge, I tried to set a visit with her, but I don't know if she wasn't notified anyway. She didn't hear. I've had initial discussion with Ms. Farrell. Ms. Franklin, you want me to represent you on this? It's Greg Farrell from the Public Defender's Office.
Yes, sir.
Okay, then if you could just keep an eye on your jail kiosks. I know sometimes they don't actually tell you that you got a video visit. I set one earlier this week, and
Repeat tomorrow. They didn't tell me.
oh, okay. Well, I'll set something to talk to you probably early next week. Judge, if we could just go maybe 2 weeks out on this, so I can talk to her.
Okay. That sounds fine, Ms. Franklin. I'll set you out 2 weeks to February 11th. Give Mr. Darrow a chance to speak with you and the state attorney.
I actually have a visit set for tomorrow with her, but you know if you'll be out of quarantine tomorrow.
Yes, I'll be out. I get released in the morning like 9.
So Janice just brought to my attention that I'm ahead of the game, and I do have, if I can give her the time tomorrow so she knows. You should have a video visit with me tomorrow at 9:35 in the morning. So,
Okay.
so I'll talk to you then.
Okay, thank you.
Sounds like 5 minutes after she gets out of quarantine.
Oh, so run.
Yeah.
I'll
Okay.
talk to you in the morning. Let me know what's
Okay, Ms. Franklin, we'll see you in a couple of weeks and see what develops. Thank you. Okay, anybody else? Because I have an old docket, so I do want to make sure. Address everybody.
I think that's enough.
I agree. It's enough folks in violation status. Okay, that'll conclude our docket. We can finish with the jail. Thank you, jail, and we can go off the record. And thanks everybody on Zoom.